Good morning. My name is Ron Fox, and welcome to the Fox Smith Legal Symposium, free to our clients every year. I want to welcome you to the seminar, and I want to thank you for attending. At Fox Smith, we understand that every matter that is sent to us is important to our client, and we treat it as such. When we get a new matter in, we work very hard to make sure that we immediately contact our clients and talk to them about what it is their goals are. We work collaboratively with our clients in an effort to make sure that they obtain an effective and efficient result promptly. We also take it as a real honor when clients send us work. And today's seminar is our effort to say thank you for the trust that you have placed in us when you send us new matters. Today, you're going to hear from a number of my partners. All of them are experts in the fields on which they're going to be speaking. We sent you an email earlier which provided you with the biographical information for each of those partners, and you can see from looking at those that they each have a great deal of experience and knowledge about the areas that they're going to be talking about. We also provided you with a listing of the different areas of law in which we practice. That should help you understand the kinds of service that we can provide. Today we're going to talk about three topics. One is employment law, especially in the era of this pandemic. The second is risk management and litigation avoidance. And the third is what happens when you're involved in a lawsuit. What are the first things you should do when you're sued? What are things that should be done as you proceed to defend yourself? And how do we evaluate cases? Before we begin, there's just a few preliminary matters I want to describe for you. First of all, I want to say thank you to Alaris Litigation Services. Because we could not do this live and had to do it virtually, we had to rely upon a top-notch videography company to provide that service to us. And Alaris Litigation Services has graciously agreed to provide that service to us free of charge. Second, I want you to know that we sent you an email just a few days ago in which we provided you with the PowerPoint presentations that you'll be seeing on the screen today. So you have those available to you for future reference. Also, these seminars are very important to us and they're important to our clients. And we make a real effort to try to communicate effectively on topics that clients are interested in. And so we would ask that at the end of this seminar, you respond to an email that we're going to send to you. In that email, you will see an evaluation form, which gives you an opportunity to rate our performance. It also gives you a chance to tell us topics that you would like for us to speak about in future seminars. Also, please know that because of the limited time that we have during the 2 hours that we're going to do this seminar, and because of the virtual nature of the seminar, we really can't take questions as we make our presentations. But if you have questions, please write those down on the evaluation form and send them back with the return email that you send to us. As our way of saying thanks for giving us the evaluations, we'll send you papers that cover some of the topics that we're going to discuss today. We are grateful that you are attending the seminar with us today, and I want to say thank you, and I hope you find it helpful and informative. And now, for the very first topic, employment law, presented by Richard Korn and Maggie Getson. Thank you.
Update in face of COVID, as well as some other topics that Richard's going to present on. But first, we just want to draw your attention to this disclaimer. Obviously, this is only for educational purposes and is not intended to convey legal advice. Obviously, if questions arise, please feel free to contact any of the presenters. Our emails are included throughout the PowerPoint, and we look forward to hearing from you. So first today, I want to talk to you about the COVID-19 update, as I affectionately refer to it as the update that simply just won't stop updating. Preliminarily, in June, Ryan Moore, Bart Sullivan, and myself presented a COVID-19 webinar which addressed some business implications in light of the current pandemic. It's only about a 50-minute presentation. I encourage you to go and watch that if you have the chance. It gives you an overview of all the different laws and different implications that come into play as a result of COVID-19 in the employment law world. So with that webinar that we did previously do, I'm not going to highlight the specifics of each of the laws, but really just kind of provide an update on some of the more recent guidance and rules that have been issued by the various departments. So the first one that I want to talk to you about today is that the Department of Labor recently issued new guidance pertaining to distance learning for students. And as many of you probably know, parents are eligible to take leave under the Families First Coronavirus Response Act for hybrid situations concerning schooling if there's no other suitable person available to assist with your child's social distance learning. So in other words, if your employee's child is in school on Monday and Wednesday, but distance learning on Tuesday and Thursday, then that employee would be eligible for intermittent leave on Tuesday and Thursday in order to assist with social learning. Basically, the social distance learning days, if they're instituted by the school, are considered off days, and therefore the school would be closed due to COVID, and therefore the leave entitlement would kick in. Now, you have to be a little bit wary because there is this parental opt-out, which the Department of Labor also issued guidance regarding. And in that parental opt-out, it really considers the fact that some schools are providing the option to parents to either send them to school 5 days a week, provide them with a hybrid situation of being in school or out of school, or just straight virtual learning. And what the Department of Labor has said is if a parent chooses to opt out so that your child is not going to school, even though they could be physically in school, then they would not be entitled to leave because really the school's not closed as a result of COVID. It's open, it's functioning, they have the option. So, of course, it's never easy. Say, for example, your school is open. This happened at my own kid's school. Your school is open, but a kid tests positive in your child's class. Well, that class is no longer going to be quote unquote open for the mandatory 10-day quarantine period. And so technically under the various laws, then that parent would still be able to get their leave entitlement because they can't send their kids to school because of COVID. Now, switching gears a little bit, I'm going to talk about the Department of Labor's recent issuance of new rules and some clarification of other rules. And for those of you who don't know, recently the Southern District of New York ruled that 4 parts of the temporary rules pertaining to the various acts were invalid under the Administrative Procedure Act. So that's just a bunch of legal jargon to say that the Southern District of New York decided some of the rules that were issued by the Department of Labor really just kind of weren't up to snuff. And so they wanted to go ahead and clarify and revise those rules. And there's 4 predominant things that really came out of that. The first one you can see listed up there is the employer approval for intermittent leave. And in this regard, the Department of Labor recently reaffirmed that when intermittent leave is available, an employee must first obtain their employer's approval to take intermittent leave. So there's no intermittent leave if you have to report to a work site and are experiencing symptoms, or you have to care for someone who has symptoms, or somebody who's under a quarantine order. Really, this intermittent leave is available for the social distance learning that we just touched on, as well if you have employees who are working remotely but are experiencing symptoms or have been ordered to quarantine. But to take that intermittent leave, you have to still have your employer's approval to do so. Now, second, I've put up there the revised definition of healthcare provider, but in my opinion, this is probably the most significant change that the Department of Labor has issued for the rules. As you can see, they've really limited what the definition is. In other words, these individuals, these healthcare providers, are going to be the ones who are actually providing patient care. And if they would not be providing that care, then it could adversely impact the patient. So the change was really due to the Department of Labor's previous focus under the old definition of healthcare provider, which really focused on the employer as a whole. What did the employer as a whole do or offer services of? But now it's really focused instead on the employee's duties. So arguably, under the old definition, a receptionist at a doctor's office could arguably have been considered a healthcare provider. But now you have to look at the duties of that individual, and they are not, a receptionist at a doctor's office isn't going to be providing these necessary provisions of patient care, which could adversely impact the patient. So examples of these healthcare providers under the new definition include the obvious ones: nurses, CNAs, LPNs, lab techs, medical technicians. But those who are not considered healthcare providers anymore include, human resources, records managers, IT professionals. And while we think, especially in a hospital setting, somebody who manages hospital records would probably, maybe be considered integral to patient care because they manage their records, the services that they provide are not necessarily related to the actual services of diagnostic and preventative services. Those those offerings that the individuals give are basically just too attenuated to be integrated and necessary components of actual patient care. So really the shift is from the employer as a whole to what does that employee actually do and how do they affect patient care. So importantly, because of this change in the definition, if you have employees who are once exempted but now are not under this revised definition, you should make your employees aware about their potential eligibility for leave and make sure that you have posted the required notice that the Department of Labor has issued, and that's available on their website. Now, the third, really as a clarification, it's not a new rule, is that the employees must provide employers with documentation, quote, as soon as practicable, supporting their need for leave. Previously, under the old language, employees were required to submit documents regarding the need and length of leave before the actual leave could begin. But rightfully so, that was inconsistent with the notice provision of the Families First Act and really the spirit of the legislation on the whole, which has been emphasized, at least by the Department of Labor, to really work with your employees within their individual circumstances. So now they don't have to necessarily get that leave or ask for that leave before it can begin. They just have to provide the requisite notice as soon as practicable. So think of the example, which I know we have seen and heard from clients about a lot recently, which is, you find out on Monday morning you've dropped your kid off at school, and then you get notice that a child tested positive or a parent tested positive. And so they're closing that class for the 10 to 14-day period. So that employee is going to have to go and pick up their kids. So they just have to notify the employer then. And arguably that would be as soon as practicable or as soon as possible. What the clarification did not change is that the employee needs to still provide documentation-wise the same things. And that really is a much lower standard than what we think of under family medical leave, ADA, because it's really just a statement from the employee, which says, here's my name, here are the dates that I'm requesting to be out on leave, my qualifying reason for leave, like I have been ordered to quarantine, or I'm taking care of a member of my family, or my kids are out of school, and then an oral written statement that the employee is actually unable to work because of the qualifying reason. So those are kind of the four predominant things for notice, but we also have to remember that in true legal fashion, the Code of Federal Regulations also provides these kind of additional provisions. So you can always look at those regulations or feel free to give us a call, but it's just kind of another layer. Like if you have been ordered to quarantine because that's what your physician says, then according to the regulations, you should tell your employee, hey, my doctor, Korn, for example, Richard over here, says that I have to quarantine. And so you make your employer aware of that. And the fourth kind of clarification is considering the work available to take leave under the Families First Act. And they basically added a caveat that an employee is unable to work or remember telework because of one of the 6 qualifying reasons. And so the Department of Labor really corrected an inconsistency regarding the language of this qualifying reason. In essence, the clarification provides what we refer to as a but-for test. In other words, but for having COVID symptoms, that employee would be able to work. The clarification was really because of downturn in production at certain employers, or employers are furloughing employees. And so employees were trying to request additional leave under the Families First Act, because they said, well, I was furloughed because of the downturn in production as a result of COVID. But what the Department of Labor is saying is, well, that's not one of the qualifying reasons. One of the qualifying reasons is because I have symptoms, or I have to take care of my kid, or I've been exposed and have to quarantine, or there's a government order or isolation order. So it really is, if an employee is not expected or required to work due to a downturn or a furlough, even though it may be related to COVID, the employee is still not and cannot take leave under the law. Additionally, in addition to the Department of Labor, OSHA also recently issued new guidance on the reporting requirements. Now, just as a refresher, COVID-19 is a recordable illness for really all employers, basically. In our June webinar, which I announced at the outset, we discussed the OSHA guidance a lot more in depth, so I would refer you back to that. Obviously, you can give us a call or read the OSHA guidance, which is for a federal agency is pretty succinct. But this new guidance is really just looking at the triggering event, which is the employee's exposure in the workplace. They put some time limitations, more or less, on COVID-related hospitalizations or fatalities as a result of workplace exposure, and when that's required to be reported directly to OSHA. So just as an outset, this only applies to the requirements to actually report this COVID exposure. It does not necessarily affect our recording obligations, which are two different things under the OSHA regulations. So for the hospitalization to be reportable, the employee must be hospitalized within 24 hours of an exposure to the virus at work. So within 24 hours, the employer must report that hospitalization, knowing that your employee has been hospitalized and knowing that the reason for the hospitalization was work-related case of COVID-19. So that 24-hour reporting obligation should arguably decrease, actually, employers' reporting obligations because of the long incubation period for COVID. In other words, you will probably end up reporting less of the hospitalizations because the likelihood of your employee being exposed in the workplace and then being in the hospital within a 24-hour period isn't all that likely to happen. Now, as to the fatalities, the reporting requirement is triggered when an employee dies within 30 days of being exposed to COVID-19 at work. So it's very similar. So from the time the employer learns of the death and knows that the cause of death was a work-related case of COVID-19, the employer actually only has 8 hours to report it to OSHA. But again, this is the caveat. Arguably, if an employee would unfortunately pass away on, say, day 31, they wouldn't have a reporting obligation to OSHA. They would have a recording obligation for your internal log, but not a direct report to OSHA. The one thing that kind of is still questionable for a lot of employers is really making the determination as to what is work-related. And the importance of determining what is work-related is kind of the theme, really, of these COVID-related laws, which is making sure that you as an employer are engaging in reasonable and good faith inquiry to really come to the conclusion whether or not your employee was exposed or contracted the virus while at work. So I'm just going to shift gears here for a second. We're going to be throwing a lot of information at you, I know, in a short time, but we wanted to highlight some of the employer liability shields that are out there. Now, this Safe to Work Act, it was introduced on July 27th of this year, and it was referred to the Senate Judiciary Committee where it remains and likely will remain for a significant amount of time. I won't go into significant detail on it just because it hasn't been enacted legislation, but something to watch, especially after the election, to see kind of what comes for it. But I think it's important to note that really it's almost like a guidance for employers, because as you can see, if you look down at the last bullet point, the safe harbor provision is compliance with public health guidelines. And actually included in the Safe to Work Act is this language that the written policy at the time of exposure is going to give a presumption of reasonableness. In other words, we were doing what we should, and so therefore the employer should not be liable. And this kind of provides us with these posts that reminds employers that you could potentially be shielded from liability as long as you're really following the guidance, you are relying on the applicable standards and that guidance, you're aware of your responsibilities, and just ensuring that you're communicating with your employees. So it's always good to make sure that you have kind of a point of contact within your organization who is kind of managing all of the different guidance and what you as an employer are doing. And if you're going to institute a plan and how to adhere to that guidance, then you definitely want to have somebody who can help you do that. And kind of instituting an effective plan should be worked through with your kind of team internally, as well with consultation with your counsel, just to make sure you're in line with all of these various regulations that are changing on a pretty significant basis. But just to highlight too, for in the employment law world at least, I think it's important that this Safe to Work Act, which is pending, it does not preempt or interfere with workers' comp or government enforcement actions or the claims of intentional discrimination we see a lot, or even a seaman's right to maintenance and cure. So while it's going to kind of address personal injuries caused by coronavirus, it's still going to not interfere with these kind of 4 other bullet points that we have on there. But kind of what is happening, at least on a state level, is that states are passing legislation to protect employers from tort claims, like the federal government was trying or is trying or may do with the Safe to Work Act. And some of those states are North Carolina, Louisiana, Oklahoma, Utah, and Wyoming. But locally for us, both Missouri and Illinois have created this presumption for individuals under the various workers' comp provisions in the state. So while it creates a presumption for certain people, which I'll talk about, that doesn't prevent other employees from filing a claim for being exposed in the workplace. It just basically gives a presumption for the covered individuals that, it's likely that you went ahead, that you contracted COVID in your workplace because basically of what you do for a living. So Missouri, as you can see up there, takes a more limited approach. It covers law enforcement officers, firefighters, and EMTs. But interesting, it specifically does not mention covering nurses, doctors, or other healthcare workers. Now, whether that will change considering the effective date is through February, I don't know, but it is not, those individuals are not specifically included in the Code of State Regulations. Now, Illinois takes a much broader approach, not surprisingly. It applies to COVID first responders or frontline workers. So that's going to include your nurses, doctors, or healthcare workers, and those who work at, nursing homes or rehab facilities, as well as individuals who are employed by essential businesses and operations. And the governor declared that some of these individuals who are covered as essential businesses are things like grocery stores, pharmacies, gas stations, obviously schools, daycares, even professional services like lawyers. So they're going to be included within this kind of presumption of occupational disease that I mentioned. Now, under Illinois, there is a caveat for the list of essential services. In other words, the people that we don't necessarily think of right off the cuff, like our first responders, our frontline workers. For the essential services individuals, they're going to have to encounter members of the general public in their position or work in employment locations of actually more than 15 people. So for a few minutes or more, I'm going to turn it over to Richard Korn, who's going to give you a little bit of information about the interaction of FMLA and ADA.
Thank you, Maggie. The Family and Medical Leave Act and the Americans with Disabilities Act, and really in particular the Americans with Disabilities Act, is a source of landmines for employers. And what I mean by that is that issues that implicate the Americans with Disabilities Act, and again, to a lesser extent, the Family and Medical Leave Act, arise on a weekly, if not daily basis in many places of employment. And before I talk in detail about these two federal statutes, with an employment law practice, we get phone calls all the time from clients who tell us about a situation that they're having with an employee, and they ask us for our advice on how it should be handled. And one of the questions we hear quite often is, can we get sued? And the answer to that question is always yes. Employers can always get sued in the most asinine and ludicrous of situations. An employee can steal from you and you can fire him and he can sue you. An employee can miss several days of work in a row in violation of an attendance policy. You can fire him and he can sue you. That's the system in place we have in our country, is that there's really no filter or screening process for lawsuits against employers. So you can't prevent yourself from getting sued, but what you can do is minimize the risk of getting sued. And we could do an entire seminar on ways to minimize the risks of getting sued in the employment context, but most importantly is good documentation. If you have employees that are not performing well, document it. If you have employment evaluations at the end of the year or every 6 months for your employees, they should certainly be documented. It's easy to sugarcoat an employee's performance because it might be difficult to tell an employee that they're not meeting expectations. But you have to bite your lip and you have to be honest and truthful with your employees, and you have to make sure that the honest and truthful message to your employees is documented. So 6 months after that substandard employment evaluation, if you decide that you want to terminate them, you have good documentation to support your termination. And I'm going a little bit off script here, but I remember a case years ago where an employee was terminated, and we looked at the most recent employment review, and the supervisor said that the employee was, quote, an asset to the company. Well, it's hard to defend an employment lawsuit filed by an employee who is most recently coined an asset to the company, and then all of a sudden you're terminating him because he's a bad employee. So anyway, back to the interaction between the Family Medical Leave Act and the Americans with Disabilities Act. The purpose of the Family and Medical Leave Act, and not all employers are FEMLA employers, and I'll talk about that in a moment, is really balancing an employee's family life and their work life. The federal law basically allows employees some leniency, some time off, whether it be a leave of absence or time off from work to care for themselves or to care for family members or to care for returning members of the military. The purpose of the Americans with Disabilities Act, which again I'll talk in more detail about in a few minutes, is number one, anti-discrimination. meaning like the other anti-federal laws that you've probably all heard of, Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, the Americans with Disabilities Act, the Missouri Human Rights Act, the Illinois Human Rights Act. Those are, generally speaking, anti-discrimination laws, meaning you can't discriminate against an employee because of his or her disability. You can't discriminate against an employee because of his or her age, sex, national origin, religion, sexual orientation now, as of most recently from the United States Supreme Court earlier this summer or late spring. So the ADA has an anti-discrimination component to it. Now, again, more generally, we're talking about these two federal statutes and COVID-19 and how to deal with employees who are sick at work or who have issues related to their health. So I'm not going to talk in any great detail about the anti-discrimination provisions. More importantly to our topic today is the reasonable accommodations provision. And that means that the Americans with Disabilities Act, assuming that you are an employer who qualifies for it, has an obligation to reasonably accommodate the known disabilities of an employee. And there is an exception if there is hardship to the employer. You'll note above on the slide that hardship to the employer is not relevant in the context of a FEMLA analysis. So first, just to talk briefly about the Family and Medical Leave Act. First and foremost, it applies only to employers who have 50 or more employees within a 75-mile radius. So there might be several people on the participating today who have just turned their brain off because they work for a company that does not have 50 or more employees, and therefore they figure that the Family and Medical Leave Act is irrelevant to them. And technically speaking, you might be right. In fact, our law firm is not technically a FEMLA employer because we don't have 50 or more employees at our law firm. However, we do have an employment personnel policy that very much so mimics the requirements or the language that you would find in a run-of-the-mill FEMLA policy. And a lot of employers, even ones that have less than 50 employees, have policies that mimic a FEMLA policy, where they do give employees time off unpaid, like FEMLA is unpaid time off, to if they're pregnant or if they have significant illnesses or they sustain, injuries at home, et cetera. And although you can't be sued for violating FEMLA because you're not a FEMLA employer, that doesn't mean you can't be sued. And what I mean by that is it's important that even non-FEMLA employers, when they are implementing and executing their leave policies, that they do so consistently. It's if you have, for example, the executives at a company can take FEMLA leave whenever they want, but the younger workers can't take, or that you don't allow younger workers to take a leave of absence when the executives at the company are permitted to take a leave of absence, you run the risk of being sued for discrimination. For example, young women at your company might have need time off for pregnancy. And even though you're not a FEMLA employer, if you are granting leave to all the executives at the company and you're not granting leave to the younger kind of out of college workers at the company, that might have a disproportional impact on women and who become pregnant. So even if you're not a FEMLA employer, the long and the short of it is you have to make special effort to apply your leave of absence policies in a consistent manner. Assuming you are a FEMLA employer, employees aren't eligible for the leave on day one. If you hire an employee on day one and they tell you on day 3 that they're pregnant and they're going to need bed rest or they're going to be giving birth in a month, they don't qualify for FEMLA. An employee needs to be employed at the place of employment for a year. Assuming they're a full-time employee, they'll have no problem getting the hours worked requirement in. But if they are a part-time employee, they have to have 1,250 hours worked in the year. And then they have to have a FEMLA qualifying condition. And what that means is that the employee has to have either a serious health condition for themselves or a serious health condition for a spouse, parent, or child. And a serious health condition means either, number one, an overnight stay in the hospital qualifies as a serious health condition, or some type of other illness, for example, COVID or the flu, or any type of illness that puts them basically out of work, incapacitated for 3 consecutive days or more. Or if they have a chronic health condition that requires them to go to a physician or to seek medical treatment more than twice a year. So when you look at all 3 of those kind of definitions or subparts to the definition of serious health condition, you realize that the term serious doesn't mean that much. It might be a serious illness, but there are certainly illnesses that employees can have that we would not consider to be, quote, serious illnesses, yet they still might be FEMLA qualifying health conditions, entitling them to leave. And if they are entitled to leave, they're entitled to 12 weeks of job protected leave. For the easiest case is a woman who is pregnant. She is working up until she is full term. She goes into labor, hopefully not in the office, and gives birth. She is entitled to 12 weeks of job protected unpaid leave. And job protected means that when she returns from her leave of absence, she is entitled to be restored to her same position or to a substantially similar position. And substantially similar position actually does mean very similar job duties, even if it's not the same job position. Most importantly, at least in my mind, and I think in terms of a lawyer, what's most important is that when they return to work, they have the same benefits that they had before the leave, and they have the same salary that they had before the leave. Because if you demote them or decrease their salary upon return from leave, you're just inviting a lawsuit, a FEMLA retaliation lawsuit. So what do you do if an employee tells you that they need leave? There is paperwork that you probably anyone here who is an HR specialist probably has a file in their file cabinet of the FEMLA paperwork that you can pull down directly from the Department of Labor website. There's a FEMLA certification form that you hand to the employee, and the employee gives it to their doctor fills it out, verifies that they do have a FEMLA health condition, and they return it to you. And assuming that they filled out the forms properly and you approve the leave, they get their FEMLA leave. Oftentimes you'll have employees who either don't fill out the form properly, or the doctor doesn't fill out the form properly, or the FEMLA health condition is definitely something that you question because you think your employee might be trying to play some gamesmanship with the leave of absence policy. And if that happens, you are entitled to get a second opinion at the employer's cost. You can have the employee go to another physician and get a second opinion on the FEMLA qualifying leave. Employers don't use that option very often, but you are permitted to do that. If you have to give your employee, you can't give an employee a certification form and say, return it tomorrow or your leave's denied. You have to give them 15 days to get the paperwork filled out. And then if the paperwork comes back and the doctor didn't fill in all the forms or fill in all the blanks, you have to give them 7 days to cure the defect. So obviously, in the context of COVID, what Meggie was talking about, you could very easily see how the Family Medical Leave Act could apply to you as an employer if you have 50 or more employees. If you have an employee that is, God forbid, sick in the hospital with COVID or gets knocked out because of COVID and they are incapacitated for a period of time, really just 3 days or more, would entitle them to the FEMLA leave. So the next topic is the Americans with Disabilities Act. And really, in my mind, I think this is where some of the biggest landmines are as far as employers and their potential liability in lawsuits is concerned. If you look on the EEOC website, they every year they put out an annual report, and they tally up, or they provide statistics as to the number of charges of discrimination that are age-based, or that are national origin-based, or religion-based, or disability-based, or race-based. And year in and year out, race claims and disability claims are the most common charges of discrimination filed with the Equal Employment Opportunity Commission. I don't know if the same statistics apply to the state agencies, meaning the Missouri Human Rights Commission or the Illinois Department of Human Rights, but I suspect that they are similar. And in order to qualify under the Americans with Disabilities Act, you only need 20 or more employees. So the breadth of the statute is wider than the breadth of the Family Medical Leave Act. So if you have 20 or more employees, and in fact in Missouri, if you have 6 or more employees under the Missouri Human Rights Act, you're covered. The first question that you have to ask in most situations, and these arise all the time because employees have health-related issues all the time. And the first question you have to ask is, are they disabled? Well, under the statute, a disability is a physical or mental impairment that substantially limits one or more life activities. And I used to work at the May Department Stores Company, which owned Famous Bar and Filene's and Robinson May and department stores around the country. We had 40,000 employees at the time that I worked there, and we dealt with employment and disability and discrimination issues literally all the time. And back in those days, which some people might say, or employers would say, would be the good old days, you knew if somebody was disabled. They were hearing impaired, they were visually impaired, they were in a wheelchair. There were the traditional notion of disability was reflected in the Americans with Disabilities Act. And that's from about 1995 to, I would say, around 2005. But at that point in time, in 2005, the disability regulations under the Americans with Disabilities Act were amended. And it really broadened the scope of what constitutes a disability. For example, employees, if you're hearing impaired or visually impaired, you're still disabled. But back in, quote, the good old days, if you had a back injury and you had problems bending over or stooping, chances are you weren't disabled. That's not so much true anymore. If you have employee who claims to have ADHD and they have difficulty concentrating, that employee might be considered disabled. If you have employees that are undergoing ongoing medical treatment, cancer treatment, they would be, could be, or are considered disabled. And if they're disabled, you have to reasonably accommodate them in their job. And what does that mean? Well, for a hearing impaired employee, for example, maybe one of those TTY machines. I had a case like that. I had a case where a woman had allergies and she claimed a disability based on allergies. Now, I'd go to the bank claiming someone who's allergic to something is not a disability in this context. But counseling the employer, we decided, well, we can do a reasonable accommodation. What do? We change the detergent used to clean the towels and the sheets at this facility, and lo and behold, the allergy issue went away. So accommodating the employee. In the context of COVID, that can mean allowing employees to work from home if they have a COVID, if they're quarantined because of COVID or they have a COVID-related illness. Generally speaking, you should work with your employees in order to arrive at a reasonable accommodation. You ultimately, as the employer, do have the final word on what's a reasonable accommodation, meaning simply because an employee asks for it doesn't mean that that's what you need to provide. But you should work with your employees and engage in interactive communications to arrive at a reasonable accommodation. And if you do, hopefully you can avoid some of the landmines that the ADA has to offer. And I know I'm getting the time limit, so I need to stop. But if you have any questions, you can call Maggie or I after the seminar.
Thanks, Richard. Okay, we're running low on time, so I'm just going to kind of run through a couple of these friendly reminders. Just more things to watch or things to kind of change within your policies. And specifically, as you can see on the PowerPoint, the Department of Labor has issued a proposed rule to clarify when a worker is an employee as compared to an independent contractor under the Fair Labor Standards Act. So it's within the comment period now, which actually expires tomorrow. And really what the rule does is just kind of take an economic reality test approach, meaning they're going to look at the nature and degree of the worker's control over their own work and the worker's opportunity to really kind of profit or loss based on their own initiative. So it's going to be solely focused on that individual's ability to kind of make their own money, supervise themselves. So that's a rule to kind of watch as they come down. Second, Richard touched on this a few minutes ago, but it's important that we are revising our EEO policies. We're getting to the end of the year. It's the time to anyway look and consider about updating your employee handbooks for 2021. But this is one thing to make sure that you include. The Supreme Court did add sexual orientation and gender identity as protected classes recently. The actual opinion issued by the Supreme Court was very narrow, and it really just pertains to this. So if you have not done so, make sure you've added those protected classes. And then quickly, just a reminder, medical marijuana sales actually began this past weekend in Missouri on October 17th. So it's now inevitable that you will likely have an employee, if you haven't already, who has a medicinal marijuana card. I know we've already talked to our clients about this when somebody can't pass a pre-screen drug test and the steps that we need to take. So in the same breath as updating your EEO policies, we want to make sure that you've updated policies pertaining to drug-free workplace and drug testing policies in general, which are all still permissible under the Missouri law. And I think it's important to highlight that your supervisors are being trained on how to identify if we think somebody is under the influence of marijuana, because while you may be able to have it in the evenings, you cannot be under the influence while at work. And so making sure that our supervisors are documenting if an individual, if they have a reasonable suspicion that somebody's under the influence at work. So again, let's make sure that we're updating your policies in regards to that. And then finally, as to our mandatory sexual harassment training, this is mandatory in the state of Illinois. It is not mandatory in the state of Missouri, but is extremely encouraged. And as you can see, Illinois, yet again, very broad. It applies to, the requirement is for employers with one or more employees. And the deadline for completion is December 31st, 2020 of this year. But again, next year, you'll have the same requirements to do that. Under the provision It is also required that employees keep records of their training. So it can be something as simple as a sign-in sheet. I know that's what our firm does for CLEs, just to track. And if you don't comply with the requirement, you can be found in violation of the Illinois Human Rights Act. So let's make sure that our supervisors are being trained. And I do want to highlight one thing, is that the training is required for any employee who works or will work in Illinois. So even if you have a supervisor, for example, who's out of Illinois but manages employees in Illinois, that out-of-state supervisor is going to need to also have the mandatory sexual harassment training. So Richard and I threw a lot of information at you. In reality, these topics could each be one presentation. So please, as we've both said, if you have questions, feel free to email us.
That's our presentation today. One, I wanted to thank, first off, Alaris Litigation Services again for hosting us and setting up the Zoom presentation for us. Number two, of course, I want to thank everyone for attending today, particularly under these very unique circumstances. If anyone has any questions, I would encourage you to follow up with any of the presenters that you heard from today. They're happy to talk to you. I would also direct you to our firm website, where there's a great deal of information. I would ask, as Ron mentioned at the very beginning of the presentation, if everyone would fill out their evaluations and the feedback, that would be greatly helpful to us. Also, if there are any topics that people would appreciate having presented on at future seminars, we would welcome that information as well, so we can provide relevant and helpful information at future programs. Again, thank you all for attending. Hopefully our next presentation and seminar that we put on, we will be back to meeting in person. Thank you all.